Okay, let's unpack this. Picture this. Sydney, 1993, a successful solicitor, a respected professional, reports her BMW stolen.
Sounds pretty routine, right? Annoying, sure, but routine.
Exactly. You'd think maybe some police reports, dealing with insurance, eventually maybe getting a new car. But this was completely different.
Yeah, this wasn't just a simple stolen car report. This was, well, the very beginning of a huge legal drama.
Hughes is right. A high-stakes battle for reputation, for freedom, that just spiraled up through the courts, didn't it? All the way to the High Court of Australia.
And in doing so, it really exposed how easily a trial can go off the rails.
Mm.
And it ended up fundamentally changing the rules for evidence in courtrooms across the country, particularly around character.
Welcome to the deep dive. We take complex information court judgments, legal analyses, source material like we have today, and we pull out the key insights, the bits that really matter, the story behind it all.
Giving you that full picture without you needing to wade through all the dense legal text yourself.
So, our mission for this deep dive, to trace this extraordinary journey, we're following the case of Stanoevski v. the Queen.
It starts, like you said, with a supposedly stolen BMW in Sydney, but it finishes with a landmark High Court decision that, honestly, still shapes how lawyers operate today.
We'll introduce you to the people caught up in it, all the accused solicitor, her alleged accomplices, the judges, the lawyers fighting it out.
Yeah, we'll follow the twists and turns, pinpoint those critical moments where things really went sideways, and look at the legal minds wrestling with these complex issues all the way to Canberra.
And our guide through this legal maze today is the source material provided, mainly bits from the High Court judgment itself, which is great because it doesn't just give the outcome. It lays out all the reasoning, the judge's analysis of the trial, the appeals.
And we also have a summary that helps set the initial scene. It's all here for us to get into.
All right, let's rewind. Back to early 1993. Section 1. The setup. So setting it, a solicitor, a stolen car, and, well, a betrayal.
Okay, so the alleged crime itself, it happened in a really specific time frame, between January 20th and February 5th, 1993.
And the central figure?
Liljana Stanoevski. She was a practicing solicitor, had offices in Bankstown and Rockdale down in Sydney.
And the charge?
Conspiracy. Conspiracy with two other women, Gloria May Wales and Mira Kutlasovska, to cheat and defraud NRMA Insurance Limited.
Okay, so insurance fraud. What was the alleged plan? How did they supposedly try to pull it off?
Well, according to the prosecution's case at the trial, it was, on the surface, pretty simple. Mrs. Stanoevski was accused of asking her secretary, Gloria May Wales.
Her own secretary?
Yeah, asking her to basically arrange for someone to take her car, her BMW, which was insured with NRMA. The idea being she could then claim the loss from the insurance company.
A classic insurance scam setup, if the allegations were true. So staged, not a real theft. How did it supposedly happen?
Well, according to the evidence given by Mrs. Wales, and this is key, she became a major prosecution witness.
Right, the secretary testified against her boss.
She did. She testified that she got another secretary in the office, Mira Kutlasovska, to actually take the car. And Wales said the car was then just left parked at her own home.
Waiting there, in plain sight.
Pretty much. And then the next step in the alleged plan, according to the Crown, was Ms. Stanoevski reporting the car stolen to the police. That happened on February 4th, 1993.
And the conspiracy charge dates wrap up the very next day, February 5th. Convenient.
Very. But, these kinds of staged things often seem to unravel pretty quickly.
They often do. What happened here?
Well, the car was found only about a week later, parked right there at Ms. Wales' home.
Ah, that would have raised some questions about the whole stolen story.
Immediately. Threw the whole official report into doubt.
And what about the other two women the secretaries allegedly involved?
Gloria May Wales and Mira Kutlasovska, they were also charged with the same thing. Conspiracy to cheat and defraud NRMA. But here's a really critical point that hangs over the whole case.
Okay.
They both pleaded guilty.
Both of them. Wow.
Yep. They admitted their roles in the alleged scheme and were sentenced for it. So you have this situation where the two alleged co-conspirators have already admitted guilt. That puts enormous pressure on Ms. Stanoevski, obviously.
And makes the testimony of Mrs. Wales, the secretary who organized it, incredibly important and potentially incredibly damaging for the defense.
Exactly. It sets the stage for a very tough trial for Ms. Stanoevski.
Okay, so we have the alleged crime, the key people involved, and a conspiracy where 2 out of 3 have admitted guilt. Let's properly introduce the players. Section 2. Dramatis personae, the people at the heart of the drama.
Right at the center, of course, is Liljana Stanoevski. A professional woman, practicing solicitor, had built a career, a reputation.
And how did she react to the charges?
A high court judgment actually quotes her calling the accusation a dreadful crime. And from day one, right through all the years of legal fights that followed, she absolutely maintained her innocence.
Never wavered on that.
Never. And that claim of innocence, that insistence that she couldn't possibly have done this, it became the absolute foundation of her defense strategy at the trial.
Makes sense. If you're innocent, you rely on your credibility, your history.
Totally. Her defense relied heavily on her reputation, her previously clean record, her good character. This is the first time she'd ever faced anything like this.
And the personal stakes must have been immense.
Oh, huge. Conviction, sentencing, she ended up getting home detention. Her professional reputation completely ruined. You can see why she fought so hard to clear her name. It's a really powerful human story running alongside all the legal stuff.
Then there's Glory May Wales, the secretary.
Yep, Ms. Stanoevski's secretary. And according to her own guilty plea and her testimony, she's the one who arranged the car theft, supposedly at Ms. Stanoevski's request.
And because she pleaded guilty, she became a witness for the prosecution against Ms. Stanoevski.
Correct, a key witness. But Ms. Wales also added another really complicated layer here.
No, what was that?
Well, after this whole alleged car conspiracy happened, she made completely separate allegations against Ms. Stanoevski about forgery in a totally unrelated family court case.
Forgery after the car incident, made by the same secretary who admitted to the conspiracy. That sounds messy.
Very messy. And those later allegations led to a Law Society investigation, which produced a report. And that report became this hugely controversial piece of evidence or potential evidence at the trial. We'll definitely get into that.
Okay, and the third person charged?
That was Mira Kutlasovska, the other secretary in the office. According to the allegations and her guilty plea, she was the one who actually physically took the car.
Right. And the victim, the intended victim of the alleged fraud?
That was NRMA Insurance Limited, the company that insured the BMW.
And who presided over the trial itself?
That was Judge Viney, DCJ, in the District Court of New South Wales in Sydney. And he made a really critical pre-trial decision. He ruled that the prosecution could cross-examine Ms. Stanoevski on those controversial Law Society report allegations about the forgery.
Ah, so he let that separate issue into the trial.
He did, and that decision became the absolute focal point of all the appeals that followed.
And finally, the ultimate reviewers, the judges who had the final say.
That was the High Court of Australia in Canberra. 5 justices heard the final appeal. Justice Gaudron, Justice McHugh, Justice Kirby, Justice Hayne, and Justice Callanan.
And their judgment, as we've said, really dissected the whole process.
Absolutely. They delivered this incredibly sharp analysis of the trial, identifying what they saw as fundamental errors in how the evidence, especially character evidence, was handled, and critically, how the trial judge used or didn't use his discretion under the Evidence Act.
So a relatively small group of people, but drawn into this incredibly complex situation. And it's that separate later allegation from Ms. Wales about forgery that really blows things open, right? Taking us to Section 3. The investigation widens, a separate allegation surfaces.
Exactly. This is where that crucial Law Society report comes from. The High Court judgment calls it a preliminary report by investigator, done for the Law Society of New South Wales. And importantly, it wasn't about the BMW theft at all.
So what was it about?
It was all about that allegation from Ms. Wales, the one she made after the alleged car conspiracy dates. She claimed Mrs. Stanoevski had forged the signatures of a client, named only as J. Fowler, on documents for a completely separate family court case.
Forged client signatures. And what else?
Wales also alleged that Mrs. Stanoevski had then improperly witnessed these supposedly forged signatures.
Okay, so a serious allegation of professional misconduct. Forgery, improper witnessing, completely unrelated to the car insurance fraud charge, made months later by the key prosecution witness in the fraud case.
You see how complicated it gets. And what did the Law Society's preliminary report actually conclude about this forgery claim?
Yeah, what did the investigator find?
Well, the report mentioned the opinion of a handwriting expert who looked at the signatures. And the High Court judgment quotes this opinion directly. It calls it highly equivocal.
Equivocal, meaning?
Meaning very uncertain. The expert basically said, and this is almost a direct quote from the judgment referencing the report, at the best, these similarities only indicate that the writer of the Liljana signatures cannot be eliminated from having produced the questioned J. Fowler's signatures.
Hold on, it cannot be eliminated. That's it. That sounds incredibly weak.
It is. It's not saying she probably wrote them, or even she might have written them. It's just we can't rule her out.
That's barely evidence at all. The High Court later called it featherweight, didn't they?
They did. It offered almost zero positive support for the forgery allegation. And the report also included statutory declarations from Mrs. Wales herself, laying out these serious but unproven allegations.
So this preliminary report is based heavily on the word of an alleged accomplice in the other crime, plus an expert opinion that basically says nothing concrete.
Pretty much. And yet, this report about a completely separate issue is about to become absolutely central to the trial for the alleged car theft conspiracy.
How does that even happen? Which brings us to Section 4. The trial strategy, character, and that critical pretrial ruling in the district court.
Right. The trial itself kicks off in the district court in Sydney, before Judge Viney, February-March 1997. And as expected, Mrs. Wales, the secretary, testifies for the Crown, gives evidence against Ms. Stanoevski about the alleged car plot.
Okay. And the defense strategy, knowing Wales is testifying and has pleaded guilty.
From the get-go, Ms. Stanoevski's defense team knew they were up against it. They made it very clear to the judge her character was going to be central. They planned to call evidence showing she was a person of good character, good reputation.
The logic being someone with a history of honesty wouldn't just suddenly commit insurance fraud.
Exactly. It's a standard, often powerful defense tactic. But the prosecution was ready for it.
How so?
The Crown prosecutor immediately told the judge, look, if the defense raises good character, we want permission to use that Law Society report, the one with the forgery allegations, to challenge her character.
Wow. So they flagged it right away, forcing the issue.
Straight away. This meant the whole character issue and the potentially explosive contents of that report were front and center before Ms. Stanoevski even got in the witness box.
Was the report itself actually given to the judge then?
It was. It was tendered, but on a very limited basis. It wasn't evidence for the jury to read or decide if the forgery allegations were true. It was just for the judge, so he could understand what was in it and rule on the prosecution's request to use it during cross-examination if the defense brought up character.
And the defense must have objected fiercely to using any of that material.
Absolutely. Vehemently. This led to a really significant argument before Judge Viney, before the main evidence really got going. Should the prosecution be allowed to cross-examine Ms. Stanoevski on these separate forgery allegations?
What was the Crown's argument for allowing it?
They pointed to specific sections in the Evidence Act, the 1995 NSW Act. They talked about the general rule against evidence that's only relevant to credibility, Section 102. Then the exceptions, like Section 103, which allows cross-examination on credibility if it has substantial probative value, and crucially, Section 104.
Section 104, what's that?
It deals specifically with cross-examining the accused person about their credibility. It generally requires the court's permission or leave. But there's an exception in subsection 4. Leave isn't needed, or rather, the restriction doesn't apply as strongly, if the defendant themselves puts their character in issue by adducing evidence of good character.
The you opened the door argument.
Essentially. They also mentioned Section 106 about rebutting denial, so their argument was technical, focused on these credibility rules and the character exception.
Okay, but according to the High Court later, something crucial was missed in that argument.
Yes. This is where the High Court said the trial started to go fundamentally wrong. In that whole argument before Judge Viney, apparently neither side referred to Part 3.8 of the Evidence Act, which deals specifically with character evidence itself.
Not just credibility, but character specifically.
Right. And critically, they didn't mention Section 112. Section 112 says flat out that a defendant must not be cross-examined about matters arising from character evidence unless the court gives leave.
So, a specific rule requiring permission just for character cross-examination, separate from general credibility rules.
Yes. And perhaps the biggest omission of all.
Right.
No reference was made to Section 192.
Section 192, the one the High Court focused on, what does that section do?
Section 192 is vital. It basically says that whenever the Evidence Act requires a court to grant leave or permission for something like under Section 112 for character cross-examination, the court must consider a specific list of factors before deciding. It's a mandatory checklist.
A checklist the judge has to go through, and nobody mentioned it.
Apparently not. Neither the prosecution nor the defense drew the judge's attention to Section 112 or the mandatory considerations in Section 192.
Wow, okay. So based only on the arguments about credibility exceptions under Section 104, but not the specific rules for character leave in Section 112 or the mandatory checklist in Section 192, Judge Viney made his big ruling.
He did. He decided. His ruling was, if the defense brings evidence of Ms. Stanoevski's good character, then yes, he would allow the prosecution to cross-examine her on the forgery allegations contained in that Law Society report.
Even though the defense argued it would be incredibly unfair and risk a trial within a trial.
He acknowledged those concerns. The judgment notes he was aware of the arguments about incurable unfair prejudice and the risk of getting bogged down in the forgery issue instead of the car theft charge.
But he allowed it anyway. What was his reasoning?
His reasoning, as the High Court later described it, kind of put the onus back on the defense. He basically said, look, it's her choice to raise good character. If she does, the Crown has this report, they feel seized with it, and they feel obliged to put these matters to her.
Obliged, like they had no choice.
That's the language the High Court picked up on. So Judge Viney rejected the defense application to block the cross-examination. He said he would grant leave, permission. Though, again, the High Court pointed out he didn't actually refer to the specific power he was using, like Section 112, or, crucially, mention considering the mandatory factors under Section 192.
That idea of the Crown being obliged seems questionable. Surely it's always a prosecutor's discretion what evidence to use.
Exactly. And the High Court later said that was a flawed way of looking at it. But at that moment, the ruling stood. The defense now knew, bring character witnesses, and Ms. Stanoevski faces cross-examination on those very serious but very weakly supported forgery allegations.
That puts them in an absolutely terrible position, doesn't it? A real catch-22.
A huge tactical dilemma, which leads us right into Section 5. The trial continues, character on display, and the firestorm of cross-examination.
Despite that ruling hanging over them, the defense went ahead with the character strategy. They even got some character evidence in during the prosecution's case, right?
Yeah, a small point. But her counsel got a police officer, Detective Senior Constable McGillicuddy, to confirm on the stand that Miss Stanoevski had no prior criminal convictions. Just getting that basic fact out there early.
But the main event was when she testified herself.
Absolutely. Miss Stanoevski took the stand in her own defense. She swore she'd never been convicted of anything. This was the first time she'd ever been accused of such a thing, calling the conspiracy charge, again, that dreadful crime. You can imagine her trying to project integrity and disbelief.
And knowing the judge had allowed cross-examination on the report, her own lawyers decided to address it first during her main evidence. Kind of a preemptive strike.
Exactly. It was a tactical move, forced by the judge's ruling. Rather than just wait for the attack, they asked her about the Law Society report and Mrs. Wales's forgery allegations directly.
How did she respond?
Forcefully. She called the allegations blatant lies, totally untrue, outrageous. She mentioned a full investigation of her practice had happened, implying nothing came of these claims, trying to neutralize it up front.
Did it work? Did it neutralize the issue?
Well, then came the cross-examination by the Crown prosecutor. And according to the High Court's description, it was pretty intense.
How so?
The judgment highlights the sheer length of it. The cross-examination of Ms. Stanoevski on these report-related matters took up 15 pages of the transcript, out of 102 pages for her entire testimony.
Wow, 15%. Almost entirely on the side issue, not the actual car theft charge.
Yeah, that's what the High Court noted. Almost entirely focused on the Law Society report, the family court documents mentioned in it, the forgery allegations, the witnessing of signatures.
And this created a big problem, didn't it? Because the jury heard all about these allegations.
But they never actually saw the report itself or the family court documents, because they weren't admissible as evidence for the truth of their contents. So, the allegations and the contents were getting into the jury's minds through the prosecutor's questions, even though the underlying documents were off limits.
That just feels fundamentally unfair, hearing accusations based on things you can't even see or evaluate yourself.
That was precisely the High Court's conclusion later. Now, during this long cross-examination, Ms. Stanoevski consistently denied forging anything or acting improperly. But she did make some concessions under pressure.
What did she concede?
She accepted that some of the signatures that were supposedly the client Jay Fowler's didn't really look like the client's usual signature. And critically, she conceded that it might have happened, her word that she had signed an affidavit as a witness when the client wasn't actually there, based on someone else telling her the client had already signed it.
Even if she denied forgery, admitting she might have witnessed improperly, that could still hurt her credibility badly, couldn't it? Especially as a solicitor.
Definitely. It paints a picture of potentially sloppy practice. even if it wasn't dishonest. The prosecutor really pushed hard, invited her to speculate why Mrs. Wales might be lying, suggested she was lying about Mrs. Wales, tried to get her to explain why Wales might forge things. It was wide-ranging.
Sounds like it really did become a trial about the forgery allegations.
It risked becoming that. The prosecutor even tried to formally tender the actual family court documents into evidence at the end of this, but the judge correctly refused, saying they weren't relevant to the conspiracy charge.
And the defense called other witnesses, too. Independent character witnesses.
Yes. To try and bolster her reputation, people like another solicitor, a Mr. Walsh, who testified about her honesty and integrity.
Was he cross-examined about the report issues, too?
Sort of indirectly. The prosecutor didn't ask him about the forgery, but asked him about professional standards. Specifically, the proper way to witness affidavits.
Ah, setting up a contrast.
Exactly. The prosecutor got Mr. Walsh to agree that witnessing a signature when the client isn't present, even if you're told they signed, would be unwise practice. This cleverly linked back to Ms. Stanoevski's own concession, reinforcing that idea of potentially lax conduct in the jury's mind.
It really does sound like the trial got completely sidetracked by these collateral issues.
It certainly seems that way from the High Court's description. And that focus carried right through into Section 6, closing arguments, and the judge's summing up.
What happened in the closing speeches?
Well, the appellant's counsel tried to point out the lack of real evidence behind the Law Society report stuff, arguing there was no proof a formal complaint had even been lodged.
But he was limited in how far he could go with that.
Yeah, the judgment notes he wasn't allowed to suggest that the prosecution could have called evidence from the Law Society to back up the report or confirm a complaint, which, you might expect them to do if they were relying on it heavily. So that limited his ability to challenge the foundation of those allegations.
Okay. And then the judge had to guide the jury through all of this. How did Judge Viney handle the summing up, especially regarding the report and the cross-examination?
He gave some specific directions. He correctly told them, standard stuff, that lawyers' questions aren't evidence, only the answers matter. And importantly, he explicitly told the jury there was no evidence before them that Mrs. Stanoevski had actually forged J. Fowler's signature.
Okay, that's clear. No evidence of forgery.
Yes. But then he addressed her concession about possibly witnessing the affidavit without the client present. He summarized it, saying she conceded she might have purported to witness his signature when the client was not present. And he added, maybe softening it slightly, that this might have been done as a matter of convenience.
Convenience. But did he comment further?
He did. He spoke about the importance of proper procedure for sworn documents, saying something like, if we all accepted some sort of slapdash approach, then sworn documents would have no effect.
Slapdash approach. That's quite pointed language from the judge about her potential conduct.
It really is. And he then directly linked this to her character defense. He told the jury that if they found she had operated in a slapdash way, this could affect their assessment of her good fame and character.
So use the slapdash finding to undermine her character evidence.
Yes, but he also added a crucial technical legal direction. He said they were not deciding if she was guilty of professional misconduct, like forgery or improper witnessing, and critically, even if they found her to be of bad character because of this slapdash approach, they could not use that finding to strengthen the prosecution's case that she committed the car fraud.
Right. So the bad character finding could only weaken her defense argument. I'm a good person. I wouldn't do this. It couldn't be used as positive proof that she did do the fraud.
Exactly. It's a very fine distinction for a jury of laypeople to grasp and apply. Can use it one way, to doubt her character defense, but not the other, as proof of guilt for the crime charged.
That sounds incredibly difficult to keep straight in the deliberation room.
It does. And despite those directions, the jury came back with a guilty verdict. Ms. Stanoevski was convicted of conspiracy to cheat and defraud on June 27, 1997.
That's sentenced.
Sentenced to 9 months, fixed term imprisonment, served via home detention. That sentence finished in March 1998. So the trial stage ended in conviction. But the legal battle was far from over.
Naturally, she appealed. Take us to Section 7, the First Appeal Court of Criminal Appeal, NSW. Who heard this appeal?
It went to the NSW Court of Criminal Appeal, heard by Chief Justice Gleeson, Justice Ireland, and Justice Bruce.
And what was the outcome there? Did they see the problems the High Court later identified?
Not really, no. The High Court judgment notes that the arguments presented in the CCA were actually somewhat different from the arguments that eventually succeeded in the High Court.
So the focus wasn't quite the same.
Apparently not. Justice Bruce gave the main judgment, with Justice Ireland agreeing. They looked at the trial judge's decision to allow the cross-examination on the Law Society report material, and they found no error. They didn't think the judge had wrongly exercised his discretion.
I thought it was fair enough.
They concluded it hadn't caused undue prejudice under Section 135 of the Evidence Act. But here's that recurring theme again. The High Court judgment specifically points out that, once again, no reference seems to have been made to the mandatory considerations in Section 192 during the CCA arguments or in their judgment.
Still nobody picking up on Section 192. That's remarkable.
It does seem that way based on the High Court's account. Chief Justice Gleeson agreed with dismissing the appeal, but added some extra thoughts. He cited older cases like R. v. Stolder for the principle that once an accused puts their character in issue, basically every element, tending to establish or refute his good character, becomes, in theory, technically admissible, subject only to the judge's discretion to exclude it if it's too prejudicial or time-wasting.
So that broad opening the door idea again. If you claim good character, almost anything about your character is potentially fair game.
That was his view. Chief Justice Gleeson stated clearly he thought there was no error by the trial judge in allowing the cross-examination about the forgery allegations. He conceded it created a practical difficulty for Ms. Stanoevski having to deal with this unrelated issue.
A difficulty? It sounds like it derailed the trial.
Well, Chief Justice Gleeson felt the trial judge's directions to the jury about how to use the character evidence were adequate to manage any prejudice. He also made a point of noting that Ms. Stanoevski's defense counsel hadn't actually objected to those specific jury directions on character during the summing up.
Is that significant?
It can be. Failing to object at the time can sometimes limit appeal grounds later. Gleeson CJ went further, actually. He characterized the defense decision to bring up the Law Society report themselves in Ms. Stanoevski's evidence-in-chief after the judge's ruling as a purely tactical decision.
Tactical. The High Court said they were forced into it.
Exactly. But Gleeson CJ's view was they made a tactical choice and she had to suffer the consequences. He felt the cross-examination had been kept within manageable bounds.
Manageable bounds. 15 pages on an unproven, unrelated allegation based on featherweight evidence. It's hard to agree with that assessment from this distance.
The High Court certainly didn't agree. But at that stage, the Court of Criminal Appeal unanimously dismissed her appeal. The conviction stood. Her only remaining option was the highest court in the country.
Section 8, the final showdown High Court of Australia. She sought permission, special leave, to appeal, and got it.
Yes. The case went before 5 High Court justices: Gaudron, McHugh, Kirby, Hain, and Callanan JJ. Their decision came down on February 8th, 2001.
And the legal team's involved. We're talking senior counsel by this point, presumably.
Oh, yes. For the appellant, Mrs. Stanoevski, the team was led by T.A. Game SC, with S.J. Odgers and A.S. Kostopoulos, instructed by Greg Walsh and co-solicitors. For the Crown, the respondent, it was T.L. Buddin SC, with R.A. Holm, instructed by the NSW Solicitor for Public Prosecutions. Top-tier representation, reflecting the importance of the issues.
And the argument in the High Court, the judgment says, was somewhat different, again, from the CCA. What was the crucial new focus?
This time, the arguments zero in on the procedural mechanics of the Evidence Act. The appellant's primary submission was this: the cross-examination about the forgery allegations arose directly out of the character evidence she had presented. Therefore, under Section 112 of the Act, the prosecution needed the court's leave to conduct that cross-examination.
Okay, that seems clear. Section 112 requires leave for character cross-examination.
Right. But here's the killer point they made. Whenever the Act requires leave, like under Section 112, Section 192, mandates that the judge must consider a specific list of factors when deciding whether to grant that leave.
Finally, someone is pointing directly at Section 192 and its mandatory checklist.
Exactly. The argument wasn't just that the judge used his discretion badly. It was that he failed to follow the legally required steps for exercising that discretion in the first place.
Yeah.
Because he never considered the Section 192 factors.
And the consequence of that failure.
The appellant argued that because Section 192 and its mandatory considerations were overlooked, the judge's decision to grant leave miscarried. It wasn't a valid exercise of discretion. Therefore, the cross-examination shouldn't have been allowed, the evidence obtained from it was improper, and the trial resulted in a miscarriage of justice.
This forced the High Court to really clarify how all these different sections of the Evidence Act fit together, didn't it?
It did. The main judgment walks through the relevant landscape. Right. Section 55 on relevance, Section 56 on admissibility, than the credibility rules. Section 102, the rule against credibility-only evidence. Section 103, the exception allowing credibility cross-examination if it has substantial probative value. Section 104, needing leave to cross-examine the accused on credibility unless an exception like raising character applies.
Okay, the credibility framework.
Then the character framework. Section 110, allowing defense character evidence and prosecution rebuttal. And the crucial Section 112, requiring leave specifically for cross-examining the accused on matters arising from character evidence. And also the general discretions to exclude evidence based on unfair prejudice. Section 135, discretionary, and Section 137, mandatory for prosecution evidence if prejudice outweighs probative value.
A complex web of rules. But the absolute linchpin for the High Court's decision was Section 192.
Absolutely. They focused right in on Section 192, titled, Leave, Permission, or Direction may be given on terms. Subsection 1 just says the court can put conditions on leave, but subsection 2 is the key. It says, and this is critical, without limiting other things the court might consider, the court must take into account certain listed factors when deciding whether to give leave, permission, or direction under the Act.
It's mandatory. What factors were on that list again? The ones the trial judge had to consider but didn't.
The High Court spelled them out from Section 192. A. Would granting leave likely add unduly to the length of the hearing? B. Would granting leave be unfair to a party, like the accused, or a witness? C. How important is the evidence that leave is being sought for? D. What is the nature of the proceeding? Example, limits for serious criminal trial. E. Does the court have power to manage potential problems through other orders, like adjournments?
So the appellant's argument was simple but powerful. Judge needed leave under S-112. Granting leave triggered the mandatory checklist in S-192. Judge didn't consider the checklist. Therefore, the leave was invalidly granted.
That's the essence of it. And that argument found favor with the High Court.
Leading us to Section 9, the High Court's reasoning why the trial miscarried. What was the core finding of the High Court?
The majority justices, Goerdren, Kirby, and Callan and J.J., in a joint judgment, largely supported by McHugh J. and Hain J. in separate reasons, found that the trial judge had indeed fallen into error. The fundamental mistake was failing to exercise his discretion to grant leave under Section 112 in accordance with the mandatory requirements of Section 192.
So it wasn't just that he made a bad call, it was that he didn't follow the required legal procedure for making the call at all.
Precisely. His attention wasn't drawn to Section 192, so he simply didn't consider those mandatory factors listed in Section 192. And the High Court made it clear those factors were highly relevant and needed to be weighed in this specific case.
How did they show why those factors mattered so much here? Let's take them one by one. Factor, undue length.
They pointed to the trial transcript. That cross-examination on the report took up a great deal of time, those 15 pages. Whether that unduly prolonged the hearing was something the judge was required by Section 192(a) to consider before allowing it.
Okay. And factor B, unfairness. This seems like the big one.
Absolutely critical. The High Court agreed strongly with the defense's original concerns here. They stated that allowing the cross-examination raised a very grave possibility, in fact, the certainty of unfairness to Ms. Stanoevski within the meaning of Section 192(t).
Certainty of unfairness. That's incredibly strong language from the High Court. Why were they so sure it was unfair?
Several reasons. First, just allowing such a deep dive into the collateral forgery allegation was inherently unfair. It forced this contest of credibility between her and Mrs. Wales on an issue, the forgery, where Wales herself hadn't been cross-examined at the trial.
Right. Wales's claims in the report weren't tested.
Exactly. And the unfairness was compounded, they said, by constantly referring to the report's contents and the family court documents that the jury couldn't see. They specifically called out the prosecutor reading part of Wales's inadmissible statutory declaration during cross-examination.
Introducing prejudicial material indirectly.
Yes. And they also found the repeated invitations from Ms. Stanoevski to speculate about Wales's motives were unfair and served only to distract the jury from the actual charge, the car conspiracy.
So the cross-examination wasn't just long, it was fundamentally structured in an unfair way, litigating a side issue with inadmissible material.
That was the High Court's clear view. Then factor C, the importance of the evidence. Did the judge properly weigh how weak the forgery evidence actually was? The High Court said no. He failed to consider this properly as required by Section 192(c). They came back to that handwriting expert.
The highly equivocal featherweight opinion.
Exactly. They stressed how little value it had. And they pointed out the Law Society report itself was largely based on Wales's declarations made without her being cross-examined, so the report's author couldn't reliably assess her credibility just from her written statements.
So the foundation for the whole attack was incredibly shaky.
Very shaky. The High Court basically concluded the report was simply not important enough to justify being the basis for such extensive and prejudicial cross-examination, especially when properly weighed under Section 192(2)(c). They also noted other diminishing factors. It was a single alleged incident, quite old by then, and different in nature from the conspiracy charge.
The High Court also picked up on the trial judge's comment about the prosecutor feeling obliged to use the report, didn't they?
Yes, they directly addressed that. They clarified that just because the Crown had the report didn't mean they had an obligation to use it. It was entirely a matter for prosecutorial discretion, citing cases like Richardson and Whitehorn. They acknowledged the prosecutor did the right thing by seeking permission first, but they corrected the judge's underlying idea that there was some kind of duty to use it once character was raised.
And what about the CCA's view that the defense made a tactical decision to raise the report first?
The High Court disagreed with that interpretation, too. They said the defense was effectively forced into raising the report during Ms. Stanoevski's evidence because of the judge's earlier ruling that he was going to allow cross-examination on it anyway. It wasn't a free choice. It was damage control prompted by the judge's flawed initial ruling.
So putting it all together, the failure to follow the mandatory steps in Section 192, the flawed reasoning about prosecutorial obligation, what was the ultimate consequence in the High Court's view?
The consequence was that the trial was fundamentally flawed. It wasn't conducted according to law, and this procedural failure amounted to a miscarriage of justice.
But the Crown must have argued, okay, maybe there were errors, but the evidence was strong, she would have been convicted anyway, the no substantial miscarriage argument.
They did argue that. They said the overall case was strong enough, and the judge's directions to the jury fixed any potential prejudice from the cross-examination. But the High Court rejected this argument. They found the Crown had failed to prove there was no substantial miscarriage.
Why? What was their reasoning?
They emphasized how important character was in this specific case, an important aspect, at the forefront, something the Crown itself had conceded.
And her credibility was everything, especially when it was her word against her secretary who had already pleaded guilty.
Precisely. Her credibility was at the heart of her defense. Undermining her formidable character evidence, which the flawed cross-examination did, was highly likely to have affected the jury's view of her truthfulness. They specifically highlighted that concession she made about possibly witnessing the affidavit improperly.
The concession obtained during the cross-examination they found shouldn't have been allowed.
Exactly. That concession was obtained in breach of the Act because the leave allowing the questioning was invalidly granted due to the failure to consider Rickus 192. Because of this, the High Court said it was impossible to say that the leave didn't result in a miscarriage. They concluded there was a real chance that her credibility was undermined by this whole flawed process.
The real chance test. That if the errors meant she lost a genuine possibility of being acquitted, then it's a miscarriage, even if guilt seemed likely.
That's the standard, citing cases like Raz v. the Queen. If the appellant lost a real chance of an acquittal due to the legal errors, the conviction can't stand. Given how central character and credibility were, how weak the basis for the attack was, and the fundamental procedural error in allowing it, the High Court found she had lost that chance.
So the conviction had to be overturned, but what was the final order? Did they acquit her or order a retrial?
They didn't acquit her. While the trial was flawed, they acknowledged there was still evidence presented, primarily Ms. Wales' testimony, upon which a jury is properly directed and considering only admissible evidence could potentially find her guilty. So overturning the conviction was her legal right because the trial wasn't fair, but actually entering a verdict of not guilty wasn't justified just based on the procedural error or the fact her sentence was already served. They cited Mackenzie v. the Queen on factors relevant to ordering retrials.
So an acquittal was off the table, which leads us to Section 10, the verdict and the aftermath. What was the High Court's formal ruling then?
The High Court formally ordered the following. 1. Her appeal was allowed. 2. The judgment of the Court of Criminal Appeal, which had dismissed her appeal, was set aside. 3. Therefore, her original appeal to the CCA was allowed. 4. Her conviction was formally set aside, quashed. 5. And the final, crucial order. A new trial was ordered.
A new trial. So after all those years, the conviction, serving the sentence, she was potentially facing having to go through it all again.
Potentially, yes. However, the High Court judgment itself acknowledged this was now a matter for the prosecution's discretion. They didn't just order a retrial and walk away. They specifically noted factors the prosecution should consider when deciding whether to actually proceed with one.
What sort of factors did they point to?
Things like the fact she'd already served her sentence. The home detention ended back in March 1998, almost 3 years earlier. The sheer amount of time that had passed since the alleged events, 7 years by the time of the High Court decision in 2001, the significant disruption and expense another trial would cause her, and just general public interest considerations. Is it really worth pursuing such an old case again where the sentence has already been served?
So the High Court basically said, legally, a new trial is the correct order, but prosecution, you need to think very carefully about whether it's actually practical or in the public interest to go ahead with it now.
That's a good summary. Our source material, the judgment, ends there. It gives the order for the new trial and flags those considerations. It doesn't actually tell us whether the prosecution did proceed with a second trial or if they decided to drop the matter at that point.
So the final chapter for Ms. Stanoevski herself isn't in our sources. But regardless of her personal outcome, the case itself left a huge mark on Australian law. Section 11. The lasting impact, rewriting the evidence rules.
Oh, absolutely. This case became a really significant landmark decision. It clarified crucial aspects of how the Uniform Evidence Act, specifically the NSW version here, but the principles apply widely, actually works in practice, particularly around character evidence, and, most importantly, how judges must exercise their discretion when granting permission or leave for certain things.
And the absolute headline takeaway, the thing lawyers know Stanoevski for, is the mandatory nature of Section 192, right?
Exactly. Before Stanoevski, judges granting leave under rules like Section 112 for character cross-examination or Section 104 for credibility cross-examination might have just thought about the specific requirements of that section or general fairness. Stanoevski made it crystal clear. Whenever you're granting leave, permission, or direction under the Act, Section 192.2 kicks in, and you must consciously consider that checklist of factors: undue length, unfairness, importance of the evidence, nature of the proceeding, etc.
It's not optional. It's a required step in the judge's thinking process.
Mandatory. So it fundamentally changed judicial practice. A judge can't just say, okay, character's an issue, permission granted to cross-examine. They have to stop and actively weigh those Section 192 factors. Is this going to drag the trial out unfairly? Is this fundamentally unfair to the accused, especially given the potential prejudice? How important is this piece of evidence compared to the main charge? Is it just a weak, tangential attack?
It forces a much more careful balancing act, a more rigorous gatekeeping role for the judge.
Precisely. It gives judges clearer guidance and a stronger basis for saying, no, you can't go down that rabbit hole, especially when the proposed cross-examination is based on weak or highly prejudicial material, like the featherweight evidence in this case.
How did this affect defense strategy around using character evidence? It's always risky, but does Stanoevski change the calculation?
It certainly clarifies the risks and the protections. Yes, raising good character still opens the door under Section 112. But Stanoevski confirms that the door isn't just blown wide open. The prosecution still needs leave, and the judge must apply that strict Section 192 test before granting it. This gives defense counsel a much stronger platform to argue against allowing unfair or marginal cross-examination, pointing specifically to the factors in 92.2, like unfairness and lack of importance.
And it helps prevent those dreaded trials within trials that the defense worried about here.
Absolutely. By mandating consideration of undue length and unfairness, Section 192 provides a really solid basis for judges to rein in cross-examination that threatens to derail the main trial and turn it into an investigation of unrelated, unproven side issues. It protects the integrity of the trial process.
So, a case that started with an alleged insurance scam involving a BMW ended up reinforcing fundamental principles of procedural fairness, protecting the accused from unfair prejudice, ensuring evidence rules are applied rigorously, and clarifying the vital role of judicial discretion exercised correctly according to the law.
It really highlights how critical those procedural safeguards are and how dependent the fairness of the system is on judges and the lawyers appearing before them, knowing and applying all the relevant rules. The fact that Section 192 seems to have been overlooked until the High Court stage is quite remarkable and shows why this clarification was so important.
It truly is a fascinating story, from a suburban street in Sydney to the highest court, revealing flaws, correcting them, and leaving a lasting legacy on how trials are run. Quite the deep dive we've had.
Indeed it was.
So here's something to think about, building on everything we've discussed. We know how vital a defendant's credibility and character can be, especially when their freedom is at stake. And we've seen how easily that can be attacked through questioning about unrelated, sometimes unproven, issues. So the question is, how difficult is it for the justice system, for judges, for lawyers to strike that perfect balance? How do you allow for rigorous testing of an accused person's story without letting the jury be unfairly prejudiced by side issues or weak allegations, maybe just because a mandatory procedural step like considering Section 192 was missed? Consider how much fairness really hinges on everyone in that courtroom knowing every rule, every nuance, and applying them correctly every single time.
A profound challenge, and one that goes right to the heart of ensuring justice is not just done, but seen to be done according to law.
That's been our deep dive into Stanoevski v. the Queen. Thanks for joining us.